Well, good afternoon, everybody. My name is Brad Campbell, and I'm one of the founding principals and portfolio managers with Capital Rock Investments, headquartered here in sunny Naples, Florida. I have with me today attorney and founder of Oakstone Law, Bob Kleinecht, and this is the third session in a three-part series on trusts and estates. To sort of summarize and bring everybody up to speed in terms of topics covered already in this three-part series, which, by the way, are available as recordings on the Capital Rock Investments website, and I believe also the Oakstone Law website as well. In either case, you can access archives of the first two sessions, and at the conclusion of this session, within about 24 hours, we'll have the recorded session from today posted on both websites as well. So in the first session that we did a few weeks ago, it was entitled, Do You Hate Your Trust Now? And in that, it's kind of a tongue-in-cheek title, and what we covered during that session was we really explored the possible issues commonly found in older trusts that may not be consistent with the objectives and goals that you have today. And then in the second session, our topic was ways to lighten the trustee burden. And in that session, we particularly focused on the ongoing trust administrative processes and so forth from the perspective of one serving as trustee of a trust, be that an irrevocable trust or a revocable trust. And we covered lots of topics in between there as well. And today, the name of our session is going to be Delegation, Not Dereliction of Duties. And today's session is a bit of a continuation from session 2. And today we're going to talk about, we're going to discuss the ability of a trustee to delegate components of trustee functions to third parties and possible liability relief from the perspective of the trustee in doing so. I think to sort of lay the groundwork and agenda for today's session, really what we're going to cover is the what, why, and how, and to whom of delegation of trust functions. And if you can sort of picture this as an umbrella where the trustee still maintains sort of an overarching fiduciary responsibility over all comings and goings of the trust operation, with underneath that umbrella possible areas of delegation to help the trustee perform those functions as set out in the trust document. And so with that, I'll bring our guest in, Bob Kleinecht from Oakstone Law, and we'll get the discussion going here.
Well, thanks, Brad. And I think the umbrella concept's a great way to look at this, in that I like to use the term delegating the trust functions or trustee functions because trustee always has an overarching set of fiduciary duties to, responsibly and prudently manage the trust. But that being said, what we're going to talk about today is, like you said, ways that the trustee can build his or her team out in a manner that really enhances the overall administration of the trust. So the first question really is, what functions or responsibilities can the trustee delegate? And the answer to that is there isn't really any limit to the things that can be delegated once you understand that the trustee does retain that overall umbrella responsibility. That being said, some of the functions that are typically delegated, you see here on the screen, and the number one, obviously, is investment management via an investment advisor. So the trustee can delegate the investment function to that investment advisor, a third-party advisor. Other functions that can be delegated here, property management. Maybe there's a particular property in-state or out-of-state a lot of times. It could be as simple as the family vacation home, or it could be investment property, commercial real estate, what have you. In some cases, maybe even something like timberland. And you may want a particular individual. Rental real estate is another great example. Maybe you have an apartment complex, and you may want a particular individual with expertise there to administer that asset and report back to the trustee. And of course, tax and bookkeeping. You know, we ask a lot of our trustees, and to ask them to be an investment manager, a property manager, an accountant, a CPA, and a tax wizard, it is an awful lot. So that's kind of why we're here today and talking about the different ways the trustee can get help.
Yeah, so it strikes me that judging from this slide here and some of these functions that can be delegated, it sounds like it's very much dependent on the nature of the assets held in the trust in terms of what help you're going to need and so forth, because we've covered everything from liquid, publicly traded investments to real estate to vacation properties, and I'm assuming there's a whole variety of other assets you might find in a trust that can be very difficult to manage. And judging from the description of some of the professionals up here, very few people possess all of those areas of expertise, and that lays a lot of burden on the trustee. So
that's right. I think that's something that we can all keep in mind here today, is that it's really hard to find a good trustee that is savvy enough in enough areas to really bring value to the family and the family's financial relationships. But with this delegation concept, we really don't need to find someone who's expert in everything. We can pick a good trustee and then allow him to be, or him or her to be, the manager of the trust by delegating. So
sure, that makes a lot of sense. So now, as we move on to part 2 here, we're going to talk about why you might consider delegation, again, from the perspective of one who's serving as trustee. And I see here that you've sort of drawn out maybe the #1 reason to delegate some of the functions of a trust here. Maybe we can kind of discuss that a little bit.
Sure, and I think we just hit on it really, and that is we want to give the trustee a number of tools in the toolbox, and the #1 reason for that is to give the trustee some cover and help reduce that exposure so that the trustee doesn't need to be an expert and wear 7 different hats. The trustee can really use this delegation concept to reduce liability exposure. And we'll talk a little bit in a few minutes about how that works, but sort of the classic example is maybe I name my family friend, long time friend and neighbor, as trustee over my my trust for my children and grandchildren, and she knows the family really well. She understands which siblings work well together and which don't, and is really going to be great at being an arbiter of some conversations and maybe even disagreements, and certainly knowing which family member is great with $1 and which one needs a little bit of help. But maybe she's not an investment advisor, and she's not particularly savvy in when it comes to investments. And she's really great at all those other things I just described, and she'd be a perfect trustee if she had a little help on the investment side. And so that's kind of the classic example. And again, we're talking about scenarios where you have an individual trustee. We'll mention corporate trustees a little bit later on, but a corporate trustee tries to bring all of the expertise package together, but then often lacks in that personal touch that we're talking about with the individual in my family friend example here. So
yeah, I can imagine that the corporate trustee, my sense of it is that it's a package, bundled product that encompasses all of these areas of discipline that we were talking about. And sometimes maybe there's a particular area within there that the beneficiaries or if there's an individual trustee maybe doesn't agree with, but it's part of the bundled package. So I know we'll get into that a little bit later. So moving on to part 3 here of our session, we're going to get into issues of how exactly does the trustee delegate? How does that work? How does that look? And so I know there's some legal specifics in here because, of course, in terms of delegating or unburdening yourself as a trustee from some of the liability that we've been talking about, certainly there's law and statute behind some of the parameters here. So maybe you could walk us through that a little bit, Bob.
Right. At the risk of putting everyone to sleep, I've cited a section of the Florida statutes, and this is just a little bit on the mechanics of how the delegation works. And as you can see here, the trustee is required to exercise reasonable care, skill, and caution in doing these following three things. The first one being selecting an agent, and agent is the term used in the statutes for the delegee, for lack of a better word. So if I'm selecting an investment advisor, that investment advisor is considered the agent for purposes of the statute. That's just a little vocabulary background for you. So the trustee exercises reasonable care, skill, and caution in selecting the agent, and then it says establishing the scope in terms of delegation, which really means just building the agreement and the relationship. So whether there probably should be an investment policy statement and a separate agreement, really spells out what the investment advisor's responsibilities are going to be and really what the trustee's responsibilities will be with respect to the investment advisor. And then the third part is really critical because the first two are sort of done up front, and the third part is the duty to monitor. So the trustee is responsible for exercising reasonable care, skill, and caution in reviewing the agent's actions and just really making sure that things are going well and things are tracking with the underlying mandate of the trust agreement.
I see. Okay. And then
so then the second part of the statute is that really the statute spells out that the agent owes back to the trustee a duty to exercise reasonable care to essentially follow that agreement that we just discussed. So
Bob, that sort of sounds like the definition of a fiduciary.
It does a little bit, but what's important here is the statute is making clear that the agent owes a duty to exercise reasonable care, which is not the same as a fiduciary duty. So what this statute in the note here and the slide points out is the statute makes clear that the agent does not necessarily have a fiduciary duty to the trustee. And I know it's a bit of a hot button issue these days with investment management. And so if an investment advisor with fiduciary responsibilities to the decision maker, in this case the trustee, if that's something that's important to you or to your family, it's really important to make sure that that investment advisor holds him or herself out as a fiduciary. And I know this is something that you've worked on quite a bit, Brad. So.
Yeah, our firm, as a registered investment advisor, we automatically take on the role as a fiduciary. We can't sidestep that in any way, shape, or form. And I think it's unfortunately the concept of a fiduciary is somewhat difficult to understand, and the definition has changed once or twice over the years, and there's a lot of confusion as to that. We often think of anytime we're dealing with a very large firm, well, they must be a fiduciary. Of course, they're a fiduciary. And in fact, when selecting an investment advisor, many investment advisors, particularly at the retail individual level, are not fiduciaries and not registered, and really sort of have a buyer beware type of duty rather than a fiduciary duty. So are we saying that if a trustee were to select an investment advisor to handle the investments within the trust, and that advisor does hold themselves out as a fiduciary, that relieves a lot of potential liability and burden from that trustee in that regard?
It certainly would be a more prudent course of action for the trustee to choose an advisor who is offering fiduciary duties back to that trustee. And there are a number of reasons why an investment advisor or firm may elect not to be a fiduciary. We don't need to get into all that, and there's plenty that's been written and spoken on that. But I will say that's essentially the reason why this section of the statute exists, is that a number of firms may have had concerns that delegation by a trustee to them could create a sort of quasi-fiduciary relationship that those particular firms were not willing or prepared to undertake.
So, and have never taken on previously. Really.
Exactly.
Wheelhouse, yeah.
Exactly. So this part of the statute makes clear that the trustee may delegate investment function to an investment advisor, but that investment advisor may not be a fiduciary. Mm-hmm. And that should be clear in the investment agreement that we talked about a minute ago. So,
and that's the investment agreement between the trustee and the investment advisor that we're referring to. That should be spelled out whether or not there is a fiduciary duty in that regard.
Exactly. Thank you.
Gotcha. Makes sense.
On the third part of the statute here, really makes clear that as long as the trustee follows these steps and these rules and exercises the reasonable care and caution in choosing the advisor, building the relationship and agreement, and monitoring the advisor, as long as the trustee follows those rules, that trustee will not be liable to the beneficiaries or to the trust for any action that the agent undertook, the investment advisor in this case. Again, we could be talking about property managers and other third-party advisors, that sort of thing. But as long as the rules are followed, the trustee is not going to be liable to the beneficiaries or to the trust generally for an action or negligence of the agent. So this part of the statute really makes clear that the trustee who follows these rules will not be a guarantor, for the agent's behavior and performance. So,
yeah, you make a great point there before, Bob, too, that we have to keep in mind what we mentioned earlier, that a lot of this depends upon the nature of the assets held in the trust, and it's not always liquid, publicly traded securities. It can be real estate. It can be, I would assume, an ongoing business enterprise.
That's a great example. Yeah.
All kinds of different things that fall under the category of trust assets that need to be managed with a particular expertise that you need to go out and get. So that's a very good point.
And this, again, this part of this third part of the statute is really, from a trustee's perspective, probably the main point, in that and we have that in the takeaway here. So a trustee who follows the statutory delegation rules really gets to swap a general fiduciary duty to invest prudently with a new duty to exercise reasonable care, skill, and caution in picking the right person. So it really takes a load off of the trustee's plate and transfers it to the investment advisor, because, as you can imagine, a fiduciary duty to invest prudently is a much bigger set of duties than a duty to carefully select an investment advisor. So,
yeah, this transition here really sounds like what is required of the trustee is some sort of level of competent due diligence in selecting, I think, may be the appropriate phrase there, rather than the actual investment of the assets themselves. Really, a duty to select somebody who's reasonably competent to do so instead.
That's a great point and an even better segue.
Yes, yes. So part 4, as Bob mentioned, I was trying to segue into rather abruptly, is to whom does the trustee delegate, which is a very important topic, of course. So I think the big question here is, as we go through this, is what should, if you are a trustee, or may become a trustee or wondering about this, what should you be looking for in terms of agents to delegate various functionalities to?
Yeah, and that's really the key point. What kind of, for example, to come back to the investment advisor, what kind of individual or firm are you looking for? And the first point we touched on a minute ago, and that really is your agent, a fiduciary in and of him or herself. And we mentioned the pros and cons of that. And the other things to look at, of course, are track records. So if you're a trustee or if you're if you're thinking about giving your trustee the ability to do these kinds of things, you really want to focus on professional track record for the agent. And of course, common sense comes into play here. So you're looking for references and referrals, checking to make sure the agent has not been the subject of at least too many, preferably no, professional complaints or grievances. And you know, things happen, so it's important to follow up on that and see, you know, how those were handled.
Probably very important to understand the nature of any grievances and so forth, as well as you're digging into that, not just that they exist, but for example, you know, we'll often look into, you know, was a client harmed as a result of a situation, or was it some sort of administrative regulatory issue that the person was fined for, something like that. I think we've always felt that's an important distinction to make, you know, when checking these things out. But yeah, point well taken.
It is, and again, it's common sense, it's due diligence, and the point of due diligence is to not be caught unaware. So if you're choosing an investment advisor, you don't want to be surprised later that some sort of grievance was filed. You want to have already looked at the matter and determined that it was handled properly. And so when you're making your decision, you're making it with all of the information out on the table.
So it strikes me that in going through this process of due diligence, it would probably behoove a trustee to document the due diligence process and what was revealed as a result of that. So for example, what we've been talking about, something comes up in terms of professional complaints, and the trustee, who is the delegator, has looked into that further and documented what they found and the nature of it and so forth, so that there's some sort of record of the due diligence process.
Yeah, great point. And we could do an entire webinar on great trustee documentation procedures.
Right.
That's one of probably the trustee's biggest jobs, is to document everything. But
I'll bring my pillow for that one.
But the point being that the decision should be very well documented, and a great way to do that is in something like an investment policy statement. And
yes. And
someone, that kind of brings us to the next point, an agent who is experienced in working with trust and trustees can really bring a lot of these ideas and concepts out to the benefit of the trustee. For example, the investment policy statement should clearly specify that you are investing on behalf of a fiduciary and not on behalf of an individual. There are different concerns there, of course. So, and it's, you know, at the end of the day, this stuff is pretty complicated. You know, even something as simple as opening a new account for the trust can have its little glitches and hang-ups, and they may seem minor or trivial, but the whole point of the trust and the trustee is to maintain protection over the assets. So yes. You want to make sure that you're doing your due diligence, you're choosing the right people, and you're working with someone that has an inkling of how to do these things, so that you don't make a simple little mistake and somehow void the protection that the trust was created for in the first place. So.
That's a really great point. In our experience, you know, you can't rely on a custodian, an asset custodian in the investment world, to set up an account properly according to the way the trust intended it to preserve that protection, which was the initial purpose of setting up the trust in the first place. You know, it may be set up incorrectly and go years before anybody realizes it if they're not looking over that. You cannot depend on just a custodian to double check you on those things. So that's a very, very good point. Part 5 here, we're going to get into another way to delegate, which is the concept of delegating to co-trustees. That may look something like this. So rather than, it's sort of a bundling of services within the trustee realm. So far what we've been talking about is a trustee delegating, whether it's the investment piece, whether it's the accounting and bookkeeping and tax return filing piece, or management of real estate property within the trust to third parties. And I think what we're talking about here now is something that looks a lot more cumbersome than what we've been talking about. Is this cumbersome, what I'm looking at here, Bob, and how costly is this?
Well, good question. So just to back up a little bit, we've been talking about choosing third-party, independent, non-trustees to come in and advise the existing trustee and for the existing trustee to delegate responsibility to. So what we're going to talk about just for a few minutes here is another delegation concept, which is really distributing responsibilities among multiple trustees. And this is a kind of a specialized scenario. It's often only viable for significant wealth in that you've got just a number of assets, a number of different assets, and you've maybe got a number of trustees, whether they're individuals or corporate, that have certain skill sets that you really want to take advantage of, and you like the idea of multiple trustees to begin with. So again, it's not really for everybody, and we'll get into the complexity and cost in a minute, but just to give you the basic concept, I laid it out in an example here. You have an investment, maybe you have an investment trustee, a separate trustee that's responsible for managing the family business,
yes,
a third trustee that's responsible for distributions to family members. And the key point here is those, you can think of them almost as silos, where each of the trustees will have that set of responsibilities. Each other trustee will not be responsible for any mistakes another one of the trustees makes, assuming that the first trustee is not in fact aware of the mistake and has done nothing about it. So you can't sort of turn a blind eye, but certainly trustee number one will not be responsible for trustee number three's ordinary negligence and mistakes. And another way to look at this is maybe you don't have three trustees, but maybe you have a sort of main trustee that is responsible for most of the trustee duties, and then what's a common term now is an administrative trustee or a directed trustee. And those types of trustees exist out there. In fact, there are a number of corporate trustees that will do nothing but the back office accounting, tax, and bookkeeping, and will essentially cut checks to whomever the main trustee directs them to. So there's an agreement between the trustees that the administrative or directed trustee, and directed trustee just means that's the trustee who's being directed to do everything and won't actually do anything without being directed. So
now,
we're getting a little far afield here, but so go ahead.
No. In terms,
bring me back in here.
Yeah. No. In terms of creation of an arrangement like this, I would imagine that unlike the scenario that we've been talking about so far, where there's one main trustee, and then that one main trustee who's been appointed by the grantor ahead of time is then independently permitted to delegate out investment and management and bookkeeping and tax and all the things we've been talking about. In this case, it sounds like this must be written into the trust document in advance. This is not, in other words, the primary trustee or the umbrella trustee, if you will, going back to our example in the beginning, they can't just come out and start appointing co-trustees.
Right, and the mechanism for first of all, how many trustees you may have and who those trustees are really is hardwired into the trust document. So if this is a structure that appeals to you, it is certainly something you'd want to address in the trust document. That being said, at least in Florida and a number of other states, there are statutory mechanisms to get there. But if I'm one of these trustees, I want to know that I have the authority to act. I'd really like to see that in the trust document. If that's something that appeals to you, it's not in your trust document. See Session 1, where we talked about different ways to deal with trust documents that aren't quite working out anymore. But that's a great point. That's something you really want to see in the document. Another idea is that maybe you have an investment trustee and you have two trustees, investment trustee and a distributions trustee, and that investment trustee is certainly free to delegate that duty to a third-party investment advisor. So
I see.
maybe your family friend in my example earlier is the investment trustee simply because she's a CPA. She's careful, conservative, very sage individual, but isn't necessarily an investment in all things related to the market. So
right. Nor would somebody in that position who's probably still practicing and working full-time want to take on that type of responsibility. So this gives, it sounds like there's a lot of flexibility, particularly in some states, to make these arrangements in whatever manner makes sense at that time as well, even to the extent that you're interested in these co-trustee relationships and not just delegation to third parties.
Right, and that's exactly correct. And I just wanted to come back to your initial question, which is
Sure.
What is this all going to cost, and in terms of treasure and complexity. And certainly, anytime you're adding multiple trustees, at least theoretically, you're increasing the cost. These trustees are compensated, whether they're individuals or corporate trustees. It's a big job. It's a lot of responsibility. And frankly, they should be compensated. Otherwise, you won't be able to find a great trustee to work for free because there's a lot of exposure here. And when you're adding multiple trustees, it's hard to imagine the cost coming down.
Yeah.
Certainly, and just to touch on costs in a larger framework, when you have, if I'm the sole individual trustee, which I do not do as a matter of course, by the way, I'm just using my, let's say Brad's the sole trustee, and he's now delegated an investment function to investment manager, and that certainly has a cost as well. The overall compensation of the trustee needs to take into account the individual duties that the trustee is taking on. So the trustee who delegates all investment functions to a third-party investment advisor with full discretion should reduce the trustee fee accordingly to offset the cost of the investment advisor, which is only fair. So the trick comes when you start adding multiple trustees. Each one of them may want a full compensation and may have their own delegation concerns as well. So yes, this scenario with the multiple trustees certainly does increase the complexity, probably does increase the cost. I say probably because there's really a cap, depending on the size of the trust account, there's really a cap on what all of the trustees can charge. And as a number of trustees have found out standing before a judge that their fees are unreasonable.
Well, that's what I was going to ask you too, is who determines the compensation for services of a trustee, whether it's one individual trustee, corporate trustee, co-trustees, and so forth? Who makes that determination?
The simple answer is the trust creator makes that determination by determining how much to pay the trustees right there in the document. And I've seen some documents that get very specific and offer a sliding scale of assets versus basis points. But more likely, it's the trustee compensation provisions in the document really describe a reasonable compensation scenario. There are some statutes. Some states have very specific statutes how much a trustee should be compensated. Florida does not. For example, with a corporate trustee, pretty much all of them have a published schedule of rates, and they're all very, very similar. They have different breakpoints, so maybe it's X% up to the first million for trustee A, and maybe trustee B has X% up to the first 3 million, and then there are different breaking points going forward.
I would imagine there are what sort of price searches for corporate trustees and what they charge is competition probably drives a lot of that. That's why they're very similar.
Absolutely, and especially when it's just really hard to nail down what a trustee fee should be because it really depends on the size of the trust account, the nature of the assets, and the nature of the family relationship. So it's like anything else. You should get what you pay for.
Yeah, I think the key word you used was reasonable.
Right.
Yes, rational and reasonable.
So for purposes of our conversation today, it's just important to know that if a trustee is delegating most or all of his or her or its function, that trustee's compensation will be reduced accordingly to reflect the overall fairness and reasonableness.
It sounds like if there's an umbrella situation that we've used as an analogy today where there's a main trustee, if you will, and then co-trustees in these other disciplines, that main trustee is not necessarily responsible for the negligent acts of the other co-trustees, but I would think there is some responsibility of oversight of the other co-trustees if they're the main directed trustee, I believe is the terminology used previously.
Right. So it's kind of two different concepts here. Well, the first is on the previous slide where we have three different equal trustees, if you will. They just have different responsibilities. So they're each responsible for their respective responsibilities, but not for each other's.
Yes.
A separate scenario is where maybe you have the, for lack of a better word, a main trustee.
Yes.
And then you have a directed or administrative trustee that's working with that trustee. And the directed trustee will have very, extremely limited responsibility and corresponding liability, and the main trustee will retain the bulk of that duty, liability, responsibility, pick your term. But when an administrative or directed trustee signs on, the largest parts of that agreement will be really exonerating that trustee from the bulk of the responsibility, or limiting their responsibility to the very specific tasks that they have agreed to take on, which in essence is fair. So it's a key point when you have multiple trustees. Generally speaking, one trustee is not responsible for the mistakes of another unless the first trustee was aware of it, could have done something about it, turned a blind eye, or somehow was complicit, of course. So that's a key point. And if these kinds of responsibilities and just the divvying up of liability, if that sort of thing is important to you, you can get very specific in a trust document as to how you'd like to deal with that. So
that's it.
And it's just important to keep in mind there's a lot of flexibility. You don't have to have one person as a trustee. You don't have to have one bank as a trustee. Frequently, you'll have an individual serving as a trustee for the benefits we mentioned earlier, which is those of knowing the family well, for example, knowing the trust creator well. These are my values. These are my goals with this trust. And then maybe even having an administrative or directive trustee to handle kind of the backbone or the back office. And sometimes you'll have a full-fledged corporate trustee paired with an individual trustee, and they each have different responsibilities. So, pardon my ramble there, but
no, that makes a lot of sense on a case-by-case basis. I think probably a good way to conclude is, as we were discussing this last issue here, I noted on the invitation that we actually sent out several times for these webinars that, and I believe this was your phraseology here, Bob, being a good trustee is not about control. Rather, it is about recognizing limitations and delegating where needed to best serve the interest of current and future trust beneficiaries. And I think that's really what we're getting to in all this is how best to serve the current and future beneficiaries of the trust consistent with, as you said, the grantor's wishes and values and so forth. And that's really what we're trying to accomplish with all of this, I think.
Exactly. And the sort of antiquated notion of the benevolent uncle sitting above the trustee and making all of the decisions in today's world doesn't really flow very well. And this concept resonates with a lot of our business owning or just clients that have been successful in business can understand this concept of delegation and really playing to one's strengths.
Yeah, I would think so because a lot of wealth in this country and globally is often created by small business ownership and subsequent monetization or sale, of a business.
Liquidity event.
Yeah, some sort of liquidity event, and that's just far more common today than not. And so these are all very relevant topics because of that, I think. And if the current estate tax exemption were ever to be decreased above the very high level where it is today, all of a sudden, you know, we've got all these issues that come about again, I think, too, as well. So, interesting conversation. Well, I think we're gonna wrap up for the day. If you have any additional questions or would like something specifically answered in private, feel free to reach out to myself or anybody at Capital Rock Investments or Bob directly. You can access his phone number through us, through his website. Pretty easy to find both of us right now, so we'd be happy to chat with you in private. And so we appreciate your time and attention. And with that, we will conclude. And again, you can look at for archives of all 3 sessions on either the Capital Rock Investments website or the Oakstone Law website.
And what are those addresses, Brett?
Our website address is www.capitalrockinvestments.com and
oakstonelaw.com.
oakstonelaw.com. Thank you very much. Everybody have a great week.